I thought when I come here to this room that that's something like anti-feminist conference because there's no woman here, only men. Okay, yeah, sorry for my voice. The first question because I am allergist and in this time in the spring I have all the time I have the problem with something in the air, and they're beautiful day for my allergy and they're worst day for me. So sorry because my voice is not natural now. We speak about some problems concerning one element on the procedure of acceptance of foreign documents in legal space. It means translation of documents, and I will limit this presentation only to the problem of the translations in notarial turnover, which constructs the part of the civil procedure. A little bit special civil procedure because notaries usually work on documents. They do not use some oral translation or use only from time to time. They work mainly on documents. They do not have witnesses in notarial process. So it's quite easy to understand everything concerning it. I will show you the differences as between the notarial turnover, this as a part of civil procedure, and all other civil procedure in Polish law. From in our constitution, the Polish as a language is guaranteed by Article 27 of Constitutional Republic of Poland, which establish it is a constitutional principle of the Polish states. Of course, this is the official language, but the constitution expressly is safeguarding the rights of national minorities and rights derived from the international agreement, which are ratified by Republic of Poland. On the basis of this constitutional rule, we have elaborated the special act on 7 October 1999 on the Polish language, and Article 4 of this act restates the constitutional provision and designates Polish as the official language for the following categories of authorities. It is constitutional state bodies, local self-government, local public administration bodies, public institutions and persons subordinated to these bodies, and performing public tax, professional self-government, social, professional, cooperative organization, and other entities performing public documents. Of course, there's also some other regulations concerning the usage of Polish language, and the obligation to use the Polish language does not extend to members of the Foreign Service. Whose act may be conducted in a foreign language. It is the language of the receiving state or the language of the third states, and whose declaration of intent may be made in that language, particularly where they take effect outside of Poland. It also is worth to mention that from the evidentiary point of view, translation is not a separate document. If we take a translation of document in our hands, it means we do not have another document. It's only a text of the original document transformed into another language. From the evidential point of view, the power of evidential power of documents is only in original in the foreign language. It means that document of declaration of intent in a foreign language must be in proceedings together with its translations. Because therefore, it satisfies the obligation to submit the documents or declaration in Polish. The sole translation is not an independent statement on separate evidential document. So we cannot use in Polish civil procedure only the translation without the original document, because it would be a mistake. It would be not recognized by any court, any notary or something like this. We have two different types of translation in Polish civil law. This means sworn translation and ordinary translation. According to the Polish Code of Civil Procedure rules, the translation of foreign document is in fact unnecessary. It should not be required. Of course, if a court if the court speaks foreign language, if he understands foreign language, that the judge understands foreign language, that the translation is not necessary. But it's a little bit like theory, because the general rules shows that, for example, the court may accept so-called private translation. It means not certified by sworn translator. For example, prepared by the parties themselves. There is, of course, under the conditions that the court is he just can provide it that such a translation is without errors, and he can accept it without. There is no some kinds of opposition from the another parties of the process against usage of such translation, so it can be used in Polish civil process normally. But in addition to these general rules, which are liberal in theory, but less so in the current practice, there are several special regulations in some different parts of civil law, and this should be regarded as a lex specialis in relation to the code. So, the Code of Civil Procedure does not impose an obligation that translation should be prepared by person officially authorized to translate from a given language, so it's called a sworn translator. The sole relevant provision is Article 256, which grants the court the discretion, but not an obligation to require that the foreign language document be translated by the sworn translator. So, it depends on court's decision. And court, of course, can require, at any time can produce a request for a sworn translation. Similarly, an examining person who lacks sufficient command of Polish, the court under Article 265 Par 1 of the code need not appoint a sworn translator. It is sufficient to call an ordinary translator and administer the oath provided in Article 2082 of the code. And although the code does not mandate sworn translation, judicial practice has been shaped but by the spirit of other statutes requiring sworn translation for certain documents of proceedings, and by the perception that such practice is the norm. Especially, there is a regulation of Minister of Justice of 28 January 2002 concerning legal translation, legal transaction with foreign countries, request for legal assistance, and there is a need to have document attached to the document sworn translation. As a result, sworn translation are used far more frequently in practice than is strictly required by the procedural law. And special rule of the civil procedure is notarial procedure, which is regulated in Act of 14 February 1991 of the notarial profession. And in this act, of course, this act does not expressly refer to sworn translation of documents submitted to a notary. However, Article 2.3 provides that activities may be performed in a foreign language if the notary is a sworn translator or use the services of sworn translator. Article 87.1 requires that the content of the notarial deed and other documents be translated with the assistance of an interpreter. It means that must be a sworn translator, sworn interpreter. Of course, this provision does not specify that interpretation must be sworn, which corresponds to Article 2065 of the Civil Procedure of the examination of witnesses. But in theory, a sworn translator is unavailable. The court may appoint witnesses of another person sufficiently proficient in the language to act as interpreter. It is doubtful, however, that such a practice would be permissible in a notarial proceedings. Given the strict requirements of Article 2 of the Act of the Notarial Profession, notarial act conducted in the presence of the person who does not speak Polish without an involvement of a sworn translator would likely be invalid. So we have really, the rules are so constructed that from the notarial act we can very easily to interpret the sworn interpreter as obligatory in this procedure. Of course, we have some problem bound with this, because there's a problem of equivalence of the sworn translation in notarial turnover. The main question is that whether the European Union can recognize something like the equivalence of the translator, equivalence of the translations in exchange of the document in turnover with documents from the European Union. The issue of equivalence of sworn translation within the European legal area has been recognized for many years, but this cloud translation does not affect the evidentiary value of the foreign document, but merely enables its content to be understood in the official language of the foreign state. But the matter has been comprehensively regulated by the European Union. It's unlikely to be resolved in the near future. Because we have different conditions to be a sworn notary in different EU countries. Not in any EU country in your states they are sworn translator. It's very easy to be a sworn translator, for example, in Ireland, and it's very difficult to be a sworn translator in Poland or in Bulgaria. I think it's also not too easy to be a sworn translator in Hungary. It's a profession in which we must be really fluent in a bunch of languages. And in Poland, it's also very, very difficult to be a translator. As far as I know, it's the same problem we have, for example, in Bulgaria, in which the exams are the most comprehensive and difficult exams in the life of these people. The substantive guarantees of the reliability of these sworn translators very significantly in the countries of the European Union. This is why the common market rule for services does not work for the EU translators, and the only way which is regulated by the EU role, it's to grant the citizen of other member states access to the profession of licensed translators, defined and regulated by national law. But there is no mutual recognition of sworn translators or sworn translation across the member of states, with some exceptions. We speak about these exceptions a little bit later. Because in limited cases, other certain EU instruments, we have some exceptions concerning the translation of the documents. A person fluent in Polish and in a foreign language, even if it is not a citizen of the Republic of Poland, may apply for appointment as a sworn translator under Polish law. The problem in states arises in the recognition of translation produced by sworn translators appointed under foreign law rather than Polish law. In some instances, a strict approach to foreign certified translation does not apply, as several international agreements and limited EU regulation expressly require recognition of translators prepared by the foreign sworn translation. We take a look into these exceptions. So it's quite easy, because the Act of 25th November 2004 on the profession of sworn translator, which is not addressing mutual recognition of official translations. There is some regulations concerning how to get, in this act there are some regulations how to get into a list of Polish translator. Because to be a Polish translator, you must pass an exam, and after this exam, you have a free entry on the list of sworn translators maintained by the Minister of Justice. It can occur in two ways. So by passing the Polish sworn translator examination, it's not important which citizenship you have. You can be, for example, a citizen of Taiwan, of an unrecognized regime, or you can be a citizen of China. Or by recognition of foreign qualification as equivalent to those of a Polish sworn translator. So there are two rules for the EU or European Economic Agreement country or European Union countries. to get into this list of Polish TP. It means the Polish translator list. Also on this list can be can be written in this list also the citizen of the third countries outside the EU, and after they pass the exam or there will be a recognition of foreign qualification by the Commission. There's Article 22, Act of 22nd December 2015 of the Principles of Recognition of Professional Qualification acquired in European Union member states, which is quite easy to be a Polish translator for which on the Polish list. It's quite easy to get into on the condition of Article of the Act of 27 November, but also, in the condition for the European EU citizen, there is a requirement which allow for adaptation period of the skill text. So it's not automatically, the recognition is not automatically the foreign translator to be a Polish translator on the Polish list must allow an adaptation period of the skill test from time to time if the requirement are not equal from the point of view of Polish Ministry of Justice. Okay, but regardless of which of the two official paths of the foreign translator follows, the effectiveness of the translation in Poland as a sworn translation generally arises only upon entry on the TP list, so list of the translator. Importantly, a Polish sworn translator entering on the TP list is not required to reside in Poland or hold Polish citizenship. The list currently includes translators from around the world, including not only Europe but also distant jurisdictions and even unrecognized regime, as I mentioned, Taiwan, for example. There is no equivalence of sworn translation in general, but in some kind of regulation, for example, Regulation 2016 throughout 1191 of the European Parliament of the Council of 6th July 2016 on promoting the free movement of citizens by simplifying the requirements for presenting certain public documents in the European Union. There is Article 6 of the regulation, which requires that the certified translation carried out by the person qualified to do so under the law of the member states be accepted in all other member states. But in fact, this regulation covers a very narrow set of the documents of particular legal importance to EU, because the scope of this regulation, they are only documents of civil status records, residence of domiciles, entries in criminal records, and some electoral rights concerning in local rights and European Parliament rights. So there are really small number of documents under condition of this regulation. So the importance of this regulation is very small, in fact. And but maybe it illustrates a broader trend in European legal order in the future. We have also some treaty equivalents of foreign sworn translations. There are some documents, some agreements, bilateral agreements on legal aids or legal assistance concluded by the Republic of Poland, and there is a mutual recognition of sworn translations prepared by foreign translator officially authorized under the law of the contracting state. Such provision we have in only 1, 2, 3, 4, 5, 6, 7, 8, 9, 11, I think 11 or 12 agreements. It is agreement with Belarus, with Czechoslovakia, it now applies to Czechia, Slovakia, Estonia, Italy, Lithuania, Latvia, Mongolia, Russia, Romania, and Ukraine. What's important, in reality, there is no sworn translator institution in legal order with Belarus, Russia, or Ukraine. So these agreements are without any legal significance in notarial practice, because we have an agreement, but without subject of the agreement. Under these agreements, translations certified by the competent authority of the contracting states possess evidentiary value in the territory of other states without the need of further legalization or authentication Although the treaty of the language is generally succinct, the reference to translation being ancillary to the main provision abolishing consular legation of official documents, it nevertheless establishes mutual recognition of translation performed by competent authorities. This creates a significant liberalizing effect of legal translation within the scope of these treaties. So, accordingly, if documents from the above states are submitted in Polish civil proceedings together with certified translation prepared by translators in those states, I think the translator not entered on the Polish TP list because they are local translator only with local papers. The court or notary should accept such translation as equivalent to Polish sworn translation. Of course, nothing prevents these translators from this party states from also applying for entry on the Polish TP list of sworn translator. In such cases, however, the treaty provision would not apply as the translation would already qualify as a Polish sworn translation. According to the article, we have also some examples, some problems concerning the consular translation as a sworn translation in Polish law. According to the Article 5 of Vienna Convention on Consular Relations, this article does not explicitly list translation among consular functions. But we have to remember that the list of the consular function from Article 5 is not exhaustive. It's a purpose to distinguish those consular functions that exist under international law from those requiring the consent or at least the lack of the objection of the receiving state. Since the convention does not specifically identify translations, in contrast, for example, notarial, juridical, or civil status function, such activity must be classified as other function under Article 5, number M. It means that this function, translation of the document, must be performed provided by the receiving state does not object. In practice, such objection which may be expressed towards specific consul at the moment of granting them an exequatur on the commission's letter, it's very rare. I haven't heard in my practice, in my consular practice, about any situation that it would be an objection from the receiving states on the functions, against the functions such as translations. We always, however, have the objections against the civil status record functions, really, because there are some differences between the countries, also in the Europe. We have some objections again in notarial function, but I never have heard about the translations as a function, an objection of the receiving state. It's not practical in this moment. But it's also worth to mention that this translation, unlike notarial or civic status acts in consular practice, might serve but as jus avocandi action. It means the activities performed by the sending state's authorities in the receiving state, also as jus protectionist functions. It means the assistance to the citizen of the sending state in difficult circumstances. And consuls may assist nationals in their contacts with the authorities of the receiving state. Of course, from time to time, these contacts are compulsory if the people are in the arrest or deprived of liberty in the territory of receiving states. So it's in this situation, consuls might act as interpreters in local proceedings too. But it's quite rare to use this function in consular or Polish consular practice because these functions need time, saying frankly. And also, according to the European Convention on Consular Function, there's in this convention, Poland and Hungary are not parties, but this convention I can say something like written customary international consular law, which reflects to some problems of symmetry of action undertaken by consul of the sending state, the receiving state. And such a convention is very important because in Article 4, point F, provides the consular right to act as a translator or interpreter for a citizen in the course of consular protection of assistance, reflecting the broader right under international law to protect nationals abroad. Of course, to the extent that there is nothing contrary in the law of the receiving states. But as I have told, this is it's not so often to use consular translation in practice, but because it takes a lot of time. But from the point of view of the recognition of the translations prepared by the Polish consular officers and provided under international law, or prepared by the foreign consul accredited in Poland, must be seen as the equivalent form of a translation recognized in Polish practice, because they are Polish translations, especially these which are prepared by Polish consular officers, or they are Polish translations, because the Polish consul acts as a Polish sworn translator from it's the legal regulation of the law, consular law. So, according to the Article 21 of the Act of Consular Law, the consul can prepare and certify translation of documents from Polish into official language of commonly used in the receiving states, and vice versa, to check and certify translation of such a document made by other translation on person. So, in fact, these activities are equivalent to the translation made by the sworn translator entered in the Polish TP register, because it's according to the law. From time to time, we can use also the invoke the equivalence of the official translation by consul of foreign states, but it's quite very rare. If there are such regulation, I recognize in a bilateral convention. For example, we have Article 23 of the Polish-Lithuanian Consular Convention, Article 25 of the Polish-Hungarian Consular Convention, and this convention expressly provide that the translations made by the consul are recognized in the receiving states as documents having the same legal effect and the same force as document translated in the competent authorities and bodies of the receiving states. So if you produce in notarial turnover, for example, the notarial deed from Hungary, power of attorney, together with the translation done by Hungarian consul in Poland, it means, according to Article 35 of the Polish-Hungarian Consular Convention, that there is the equivalence of such a translation, and it must be used, can be used without any further certification procedures. Some treaties regulate the methods indirectly by authorizing consul to translate documents from the sending state to language of the receiving state, or in addition to translating from the receiving state language into that of the sending state. What is important, we have also the last question I'd like to mention. There are some, in today's words of international law, we have some examples of a new some ideas concerning to use something called multilingual forms in order to waive the requirement to translate a foreign documents. There are some instruments, for example, the first example is the Hague Convention of 5th October 1961, abolishing the requirement of legalization of foreign public document. There is something like apostille clause in this convention which replaces consular legalization, and this apostille clause is in fact something it is evidentially separate document, but this document does not need any translation because it's done in many languages. It is something like multilingual forms, and it was done in order to eliminate the need for translation of this clause. It was a first example to use such an idea. Now, for example, we have 2 or 3 conventions. Most important is Convention number 16 of the International Commission of Civil Status Records, because in some Convention of Civil Status Record we have also such multilingual forms which allow us to use the document without any translation, even it is prepared by foreign authorities in a foreign language. The multilingual copy in fact, of according to the convention of Vienna Convention number 16 on 8 September 1967, 76 of the International Commission of Civil Statutes. This multilingual copy, it's not a translation. It's an original document, but written with evidentiary value. But this document written in many languages, in fact. This multilingual forms is not translation which is attached to the documents. It's a document itself. It forms ensures intelligibility without translation. But the same we have, maybe not the same, but similar in regulation EU number 1191 from 2016. We have also the documents as a service status record, certificates of survival, residence, need not be translated if they are accompanied by multilingual standard form. And there is a big difference, because here we have to produce the document itself and this multilingual standard form, which is only translation without any evidentiary value. The evidentiary value is an original document, for example, civil status record, but this multilingual translation is something which is attached. It's only the translation, but it's simplified translation, because you have to use its translation without the usage of a sworn translator, for example. The same we have, maybe not the same, but there should be not also in the European Union. There are some documents which are used in multilingual form. For example, in European European regulation on succession, number 2615, there is something like European Certificate of Succession, which serves as a proof of succession rights in the member states. And this certificate is issued with a multilingual glossary that enables authorities in other member states where a state's assets may be located to understand the document without translation. And what is important, this glossary is not the translation, this document itself. It means that the document is written in many languages. But the usage of such a document is in the same direction as it would be a multilingual form. The usage of these multilingual forms, eliminating the need for translations, occurs with the principle of procedural economy in Polish civil proceedings. The document is fully comprehensible to the court of authority without translation. If you produce the document from foreign countries with a multilingual form, you don't need which has his origin in international convention in EU regulation. You don't need to produce any sworn translation of the documents. It's quite, I think, comfortable for the people. But from the evidentiary point of view, there are some problems concerning with it, because too many notaries, for example, enter the documents from countries which are parties to this multilingual regulation, and, for example, without the original documents, only there is a multilingual form, and it's not the evidentiary value cannot be accepted by notaries. So there are some pluses of this practice, but there are also some obstacles to this, and it's not always easy to use the documents together with this multilingual form in the notarial practice. Thank you very much.